In court trials, lawyers must use evidence to support their arguments to convince the judge or jury. But not all types of evidence are accepted, because sometimes certain evidence might be irrelevant. Take opinions, for example. Opinions are an inference of facts, rather than facts themselves. If opinions are carelessly allowed into a trial's reasoning process, it would spell disaster for judicial fairness and the integrity of our court system. That is why there exists a set of laws, better known as the rules of evidence, to regulate the admissibility and use of evidence in trial. Opinions are generally disallowed, though sometimes an exception may apply if it is the opinion of an expert. But what happens when an expert gives an opinion that doesn't really require any expertise at all? Last year, in the case of Honeysett and the Queen, the High Court unanimously ruled to quash a criminal conviction because there was improper use of expert opinion to interpret CCTV images, which was found to potentially mislead the jury. The issue was whether and how a jury could be assisted by an anatomy professor pointing out the similarities of two persons between two images. In 2008, 3 armed individuals robbed a hotel in Sydney's Northern Beaches. Eyewitness accounts were limited and provided inconsistent descriptions of the culprits. Although the entire scene was captured by the hotel's CCTV system, each offender wore long dark clothing and covered their heads and faces, concealing their identities. The police arrested Anthony Charles Honeysett, alleging him to be one of the offenders involved. The prosecution evidence was mostly circumstantial. The CCTV images were also made available for the jury for their own evaluation, but the controversy in this case was the supplementing of this evidence by adducing interpretation of those images by Macy Hennenberg, a professor of anatomy from the University of Adelaide. His opinion concerned the identity of the person in the image. Professor Hennenberg examined the CCTV images and testified that one of the robbers shared various common anatomical features with Honeysett. Using technical language, he commented on their postures, being right-handed, and described the person in the images as ectomorphic, which basically means having a skinny body build, and dolichocephalic, which describes a person with an oval-shaped head. Hennenberg concluded that there were no anatomical dissimilarities between the individual in the CCTV image and Honeysett, and the prosecution used this evidence to argue that Honeysett was one of the robbers. Honeysett was found guilty in 2011. He appealed against this conviction to the New South Wales Court of Criminal Appeal in 2013, lost, and then appealed again to the High Court, challenging the admission of Professor Hennenberg's opinion as evidence. It was here where the High Court agreed and quashed the conviction, ordering a new trial. In criminal trials, witnesses are generally prohibited from expressing opinions on matters that are to be determined by the judge or jury. The role of witnesses is generally to testify only to facts, and only the judge or jury can draw an inference from those facts. The opinion rule is therefore exclusionary. However, there is an exception to witnesses with training or expertise. This is known as expert evidence, where someone has specialized knowledge of a particular field, and the opinion is wholly or substantially based on that specialized knowledge. The exception may apply, and the expert witness is allowed to testify in court about their opinion on certain issues. In Honeysett's trial, Hennenberg was simply describing the anatomical features that he said were visible in the images, which an ordinary person could have done so themselves. The court found that Hennenberg's opinion was therefore not substantially based on his specialized knowledge of anatomy, but on his subjective impression of what he saw when he looked at the CCTV images. The High Court therefore unanimously held Hennenberg's evidence inadmissible as opinion evidence. This case shows just how much the court is alive to the danger that evidence coming from persons who are presented to the jury as experts and speaking in highly technical terms, that evidence would somehow appear to be of higher probative value than a layperson's ability to do the interpretation themselves. The High Court in this case noted that Professor Hennenberg's evidence gave the unwarranted appearance of science to the prosecution case. The use of technical terms to describe those characteristics was apt to suggest the existence of more telling similarities than to observe that each appeared to be skinny. With this in mind, parties heading to trial with the aid of experts should pay attention to what the experts should and should not be commenting on, and not to abuse that evidence by dressing up an argument to give it a stronger impression than it really is. This case touches upon the ongoing issue of the validity and reliability of scientific evidence in trial, but the High Court didn't really make any broader ruling that will impact on future cases. The justification for allowing experts to offer opinion is that their expertise supplements the jury's lack of competence. Although the case of Honeysett has determined that an anatomy professor describing human features based off CCTV images is not an application of expertise, it still leaves us with a lack of detailed consideration of what specialized knowledge actually means. What is knowledge? Is there a measurable standard in the context of evidence law? Specialized knowledge demands something more than ordinary knowledge, and how can the court be certain that the expert witness is applying that knowledge to their evidence? So the evidence has some qualities of reliability, and the technique has scientific validity. Although the facts in Honeysett presents a great testing ground for these questions, as the appeal did not raise other issues such as the admissibility of Professor Hennenberg's opinion as ad hoc expertise, the High Court gave a narrow ruling which did not go to resolving these questions. In closing, for the purpose of opinion evidence, an expert witness should only comment on things to which they have the relevant expertise, and parties should not use expert opinion to give ordinary evidence an unfair appearance of science. But the case of Honeysett was also a missed opportunity to finally nail down what is meant by specialized knowledge. Without consideration for scientific validity and reliability in its evidence law, there remains an ongoing concern for the integrity of court trials in Australia.